Yes, good morning, friends. Good morning, Mr. Dalmia.
Good morning.
Yeah, and morning, Somesh.
Good morning, Sumit.
Yes. Okay, so this is 12:05 by my watch, and let us start the webinar. So, good morning, everyone. This is Sumit Pahwa, co-founder and CEO of Complinity. I am also a lawyer and company secretary with 25 years of experience, and currently serving as a CEO, co-founder of Complinity. Complinity is India's leading compliance software, helping companies comply with the laws of the country. Complinity covers over 2,000 laws and checklist of over 25,000 compliances updated on a daily basis. We're adding value to 1,000 plus companies who are using the tool spread across 50 plus industries. And organizations like Panasonic, Max Hospital, Jindal Steel, Amaron's Battery, Oberoi 5-star chain, Bikanerwala, Pizza Hut, KFC, Taco Bell in India, Toyota, DCM Shriram, JP, British Council, etc. are using Complinity compliance software. And plus we have 13 more modules on governance, risk management and compliance, like audit, internal financial controls, enterprise risk management, contract management, etc. So happy to host this webinar along with the distinguished speakers on PMLA. So introducing our first speaker, Mr. Vijay Dalmia. Mr. Vijay Dalmia is an advocate with Supreme Court of India and Delhi High Court. He's a senior litigator and a senior partner with Vaish Associates Advocates with extensive experience of more than 36 years in court. Is under PMLA, Income Tax Act, Black Money, Undisclosed Foreign Income Assets Act, Imposition of Tax, Economic Offences, White Collar Crimes, Corporate Crime, Cyber Crime, etc. Mr. Dalmia was an additional council of years of government of SCDT in international publications, and has also authored a book on anti-money laundering laws titled A Guide to the Law of Money Laundering. So welcome, Mr. Dalmia, and thank you for accepting to be a speaker today. Also introducing our next speaker, Mr. Somesh Kumar. Mr. Somesh Kumar is a fellow member of ICSI, law graduate, MBL from NLS Bangalore, AML and KYC certified from Indian Institute of Banking Finance, Chief Insurance Executive from Indian Insurance Institute of India, and is the head company secretary, legal and operations of Cars 24 Financial Services. Sumesh has over 11 years of experience in managing business, finance, and legal affairs of BFSI industry, banking, financial services, insurance. And he has experience in launching financial products, in lending, motor, credit insurance, setting policies, procedures, controls, processes, etc. So welcome, Somesh, to the webinar, and thank you for accepting the request. So it's a very good, I would say, forum of speakers, because Mr. Dalmia represents the practicing side as a senior litigator with 35 years of experience into dealing with these white collar crimes, and Somesh represents the corporate side, sitting on the corporate in BFSI, companies, and launching the policies, programs, procedures, records, etc. under PMLA and related compliances. So a very nice mix of sort of speakers. And coming to the topic of today, the PMLA. Now, PMLA Act has been here since 2002 to prevent money laundering and to provide for confiscation of property derived from money laundering. The Act primarily applied to financial institutions and intermediaries, including banks, insurance companies, NBFCs, stockbrokers, stock exchanges, and other entities involved in financial transactions. So primarily, a financial industry, applied to the financial industry. The Act required these entities to maintain records, to do KYCs. So no wonder, all the KYCs that we as consumers have to do with banks and depositories and all these things were deriving force from the PMLA. Now, suddenly the PMLA has caught fire or caught attention by virtue of two notifications dated 3rd May and 9th May, wherein by virtue of the notifications, the chartered accountants, company secretaries, and cost accountants have to be have been brought in the ambit of PMLA, and also things like acting as directors in companies, or giving any company a registered office, or acting as a trustee, in a non-profit company, or even a director in a Section 8 company, and related aspects have suddenly been classified as activities within PMLA, and therefore all these professionals who are doing these kind of activities suddenly become reporting entities. Reporting entities means these financial institutions. So these financial institutions were earlier classified or defined as reporting entities, and therefore there were obligations on maintenance of records, due diligence, reporting to the FIU and other reporting regulators. Suddenly, the CACS, CACS and CMAs brought in on the same canvas, and directors and directors also cast that kind of responsibility, makes it very important and onerous to individuals who may not be aware of or trained on PMLA. So today, that's the context of today's webinar. Mr. Dalmia will give an overview of PMLA, because before we jump onto the notifications, it's very important for us to have an overview of PMLA, what the Act talks about, what are the key provisions, etc. And then Somesh will talk about few compliances and obligations from the corporate side, and then deep dive into the notification. So, and then we'll of course have Q&A towards the last 15-20 minutes. So from 12 to 1:30, that's the timing. And if you have any questions, even during the webinar, put it in the Q&A box. I will see either to moderate that and ask the question in the middle, or we will take it towards the end of the relevant session and ensure the flow of the webinar. So over to Mr. Dalmia for overview of the PMLA. Mr. Dalmia.
Hello, friends. It is absolutely necessary to understand what is money laundering, and the reason being that most of the people are confused about the concept of money laundering as far as Prevention of Money Laundering Act is concerned. So I will take you through a presentation that I have prepared, and I hope that I'll be able to convey what I want to make you understand about the aspects relating to money laundering. So I am sharing my screen, and share. Just a minute, please. I'm sharing. Oh, stop share. I'm sharing my screen. Just a minute, please.
In the meantime, while Mr. Dalmia is sharing his screen, just to tell the audience that the this webinar is being recorded, and the snippets of this webinar will also be posted on our YouTube channel. So you can please subscribe to our YouTube channels for regular updates on videos of this, as well as previous and for the webinars.
Is my screen visible now?
Yes, Mr. Dalmia, it's visible.
Yes. So Section 3 of the PMLA deals with the offense of money laundering, which states that whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party is actually involved in any process or activity connected with the proceeds of crime. So what does it mean? That it is not necessary that there has to be a direct involvement of the accused in the offense of money laundering. It can be direct, it can be a kind of abatement, it can be indirect. Secondly, the attempt to indulge means actual commission. Besides the actual commission, even the attempt will constitute the offense of money laundering. Knowingly assist, knowingly is a party. So knowledge has been made an important aspect of the offense of money laundering. But when we go to the next point, is actually involved in any process or activity connected. So by these 2 points, one thing is clear, one thing is coming out, that it is not necessarily that there has to be knowledge always. If somebody is participating or actually involved in any process, even without knowing that the person is involved in any process or activity that is connected with the proceeds of crime, that person will be held liable for money laundering. So knowingly or not knowingly, but actually involved in any process or activity connected with the process of money laundering, is involved in its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. So what does it mean? That, let me take an example. Somebody has taken bribe, and after taking the bribe, he has spent that particular money that has been taken by bribe. So it will fall into the category D, that is used. The money has been used. It is not always necessary that money should have been converted or invested into. Somebody with the proceeds of crime, including its concealment, possession. If somebody is even in possession of the proceeds of crime, we will come into the definition of proceeds of crime, or have acquired the proceeds of crime or used and projected or claiming it as untainted property. So the projection is also necessary, and claiming it as untainted property, that this particular money, that is the proceeds of crime, is not involved in the act of money laundering, is not connected with money laundering, is not amount related to bribe. The example which I have taken, shall be guilty of the offense of the money laundering. So all these ingredients, these components are necessary for constituting the offense of money laundering. Now there is an explanation to offense of money laundering that has been given in this section. That is, for the removal of doubts, it is hereby clarified that a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assist or knowingly is a party or is actually involved in one or more of the following processes or activities connected with the proceeds of crime, namely concealment, acquisition, possession, or projecting it as untainted property, or claiming the same to be an untainted property. So this is an explanation which is connected with the main definition of the money laundering. Claiming it as untainted property in any manner whatsoever. The process or activity connected with the procedure of crime is a continuing activity. Now, this is very important point, that the Money Laundering Act came into effect in the year 2005. This we have to understand very carefully. The process or activity connected with the procedure of crime is a continuing activity. Continuing activity means that it doesn't end at the particular point of time when the bribe was taken. I am taking this particular example of bribe again and again for the sake of understanding and explaining. Continuing activity. So the money laundering, if you are enjoying the proceeds of crime, even after, if you had taken the bribe before 2005, but you are enjoying that particular amount that has been taken as bribe, even in the year 2023, then the offense of money laundering will continue to exist as on date, that is even on 2023. You took the bribe, you purchased a property in 2004, 2002, 2003. The Money Laundering Act came into the year 2005. So actually you have exhausted that money in the year 2004. But you are enjoying those proceeds of crime. The enjoyment of those proceeds of crime are still existing in the year 2023 because you had purchased a property. In that particular case, the offense of money laundering continues. So money laundering offense is treated as a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment, possession, acquisition, use, projecting it as untainted property, claiming it as untainted property in any manner whatsoever. So the offense of money laundering doesn't come to an end merely when the offense is committed or merely when it is converted into something else, something different, for the purpose of concealment, for the purpose of possession, for the purpose of acquisition, use, projecting it as untainted property, claiming it as untainted property in any manner whatsoever. So, what is the concept of money laundering? In this particular concept, we have to first concentrate on concealment. One has taken bribe. The bribe money has been kept in a locker, secret locker. This will fall into the category of concealment. It will also fall into the category of possession. If somebody has acquired the proceeds of crime, even that particular aspect will lead to commission of the offense of money laundering. Use of the proceeds of crime will also amount to money laundering. Projecting it as untainted property. What happens? What does it mean? It means that what you have done, that you have invested the money that was taken by way of bribe in a real estate property. In real estate property, what you show that you have taken loan from the bank. Suppose the value of the property was 1 crore rupees. You have paid 25 lakh rupees in white and 75 lakh rupees in black. So what you are doing, you are showing rupees 75 lakh as untainted property in the garb of a property that is purchased in white for rupees 25 lakh rupees. Actually, its worth is 1 crore rupees, in which 75 lakh rupees are is the component of black money. So here, what you are doing, you are projecting it as untainted property, or you are claiming it as untainted property in any manner whatsoever. So this is a very wide definition. Now, the explanation continues. The expression money laundering ordinarily means the process of activity of placement, layering, and finally integrating. There are three steps which are involved in the offense of money laundering. This is placement. First of all, you place that money which is tainted. The technical word is tainted money. Tainted money into the proceeds of crime, into the white channels, in the legitimate channels. Then what you do, you start circulating and you start layering and you start transacting that money in many ways. You move that money through many channels, and after moving that money through many channels, finally at one stage you start projecting that money by integrating in the white economy, by integrating the same in the legitimate channels. Like the example which I have given, that you have purchased a property of 1 crore, 25 lakh rupees was the white component, 75 lakh rupees was the black component. So when you are giving the money, 75 lakh rupees, it is placement of money. Thereafter, you are registering this property for 25 lakh rupees. You are layering that 75 lakh rupees in 25 lakh rupees. And finally, you are projecting as if that property has been purchased for 25 lakh rupees, whereas its actual value, actual worth is 1 crore rupees. The tainted property in the formal economy of the country. Money laundering is not limited to the happening of the final act of integration of tainted property in the formal economy to constitute an act of money laundering. So, what is the definition of proceeds of crime? That is very important. Means any property. Now, what do you mean by the word property here? The property may be of any form. It may be tangible, it may be intangible. Means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Here we are stopping. Now, all offenses do not fall into the category of money laundering. Under the Prevention of Money Laundering Act, a schedule has been given. Part A, Part B, Part C. Certain offenses have been defined. If you commit any of those offenses only, and you generate money out of those by committing those offenses, only then you will be liable for commission of the offense of money laundering. So, money laundering is a second offense. Though it is a standalone offense, but it is a second offense. Second offense means that it is not an independent offense that can be committed. First of all, there has to be a prior scheduled offense. There has to be a predicate offense that ought to have been committed. So, let me make you understand one more thing. I receive queries from the client that I would like to report certain acts of money laundering by a particular person to the enforcement directorate. Now the question is, can you directly register a complaint with the enforcement directorate? The answer is no. There is no such procedure. Before an offense of money laundering is taken cognizance of by the enforcement directorate, it has to be a scheduled offense. there has to be an FIR or a complaint in place or a prosecution in place, and only on that basis the Enforcement Directorate will initiate proceedings under the Prevention of Money Laundering Act. So you cannot directly go to the Enforcement Directorate and file a complaint. There is no such authority. Before the Enforcement Directorate, there has to be a prior complaint, maybe in the form of FIR, maybe in the form of a complaint or something like that. But you cannot directly approach the Enforcement Directorate for registration of an ECIR. That is a complaint. So it is very important to understand that proceeds of crime means property. Property of any kind that may be imaginable. Secondly, which might have been derived or obtained directly or indirectly by any person. Who is the person? You imagine the definition of person, and that entity, person, artificial entity, jural entity, everything is covered. Trust is covered, society is covered, association of persons is covered, partnership covered, individuals are concerned, individuals are covered, political parties are covered. Every entity that can be put into the category or definition of person is covered. There is no limitation to it. As a result of criminal activity relating to a scheduled offense, there has to be a scheduled offense as per the schedule that is given under the Prevention of Money Laundering Act. Now, a step further. Or the value of any such property. So, that property which was generated through proceeds of crime, if that property is not traceable, then value of any such property means what you did, you committed the offense of bribery. After taking bribery, you have gone to Macau, you have spent the entire money in gambling. Now, what can be attached? The basic thing is, what can be attached? Now, the property of the accused of the value of any such property can be attached. Where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. If a particular amount has been taken, transferred out of India, now what is the way open? What is the solution? Because that property which has been taken outside India cannot be attached. In that particular scenario, the property of the equivalent value can be attached if that is available in India relating to an accused person. Can an offense under PMLA be committed without a scheduled offense? This I have already explained to you that no, there has to be a scheduled offense. I have also defined the term property as property as any property, immovable, tangible, intangible, which may include deeds and instruments evidencing title to or interest in such property or assets wherever located. Then I have also dealt with the definition of the term person, which may include an individual, Hindu, undivided family, a company, firm, association of firm, every artificial juridical person, any agency, office or branch. Continuing offense, I have already dealt. What is continuing offense? So, what is the punishment for money laundering? It should not be, cannot be less than 3 years, but the same may extend to 7 years and shall also be liable to fine. So, if you are found guilty of the offense of money laundering, then the minimum punishment that can be given by the court, for which the court will not have any discretion, is 3 years. And it can go up to 7 years with or without fine. If no prosecution under PMLA, if no predicate offense has been committed, this I have also dealt with, that there has to be a scheduled offense. There has to be a complaint relating to a scheduled offense. And only on the basis of that complaint, the offense of money laundering can accrue, can be investigated upon by the Enforcement Directorate. Okay, with that, I think my time is limited and I will end with this.
Thank you, Mr. Dalmia. You can unshare your slides. And this was an overview, a very, very high level overview of, the PMLA, what is money laundering, because before we deep dive into the notifications, it's important for us to know what is money laundering, what is PMLA, what is a scheduled offense, what is a reporting entity. On a lighter note, when Mr. Dalmia, when you were saying the property example, 25 lakhs and 75 lakhs, I think 80% or more of people, even in this forum today, would be sort of guilty indirectly or directly, of laundering, quote unquote. But anyways, the law is what it is.
I disagree. I disagree.
Yeah.
There has to be a scheduled offense.
Yeah, you would be in the balance 20%, of people in this forum. So that is on that. Now coming to when I was going through the schedule as I was preparing for this webinar, part A, part B, part C. Even part A has more than I think 25-30 paras, and any act that you can imagine where fraud, cheating, any wrongdoing can happen, that act has been mentioned as a scheduled offense. There are several sections of IPC. There are so many other immoral trafficking act and so many other acts, including Companies Act also. I was happy to find section 447 fraud that has been mentioned also as a scheduled offense. And of course, all the other acts where sort of any offense with financial implication or financial transactions can happen has been mentioned in the annexure of PMLA. And as Mr. Dalmia said, any offense under PMLA first has to have has to be an offense under those schedule, under those acts, and then it also constitutes under PMLA with a separate machinery, separate mechanism, etc. So on that note, Mr. Dalmia ended a reporting entity. Now what has been done is under the PMLA, the reporting entities were people like banks, financial institutions, stock brokers, stock exchanges, insurance companies, etc. Suddenly on 3rd May and 9th May, by virtue of these two notifications, I think primarily starting with 3rd May, the chartered accountants, company secretaries, and CMAs the certain activities have been defined, and if as per definitions, anyone doing those activities will automatically become a reporting entity as far as the definitions are concerned. So therefore, all the CMAs who are involved in incorporation of companies or even otherwise people acting as directors, people lending their registered offices suddenly become reporting entity. Now I'll hand this over to Somesh to take it from here as to now when all of these people become reporting entities, what are the obligations cast on reporting entities? What are the compliances to be done by reporting entities? What are the safeguards to be ensured by reporting entities? Maintenance of records, due diligence, etc., etc. If you could share your experiences, the law, notification, etc. Somesh, over to you.
Hi everyone. I think my screen is now visible.
Yes, Somesh.
Yeah, so this is overall legislation that we come to know about PMLA in 1972 when newspaper published the term money laundering first time, and that newspaper is The Guardian, right? So that was a Watergate scandal happened, and in the last slide I mentioned, and summarized PMLA, the last line talks about reporting entities, right? And now reporting entities also covers chartered accountants, company secretaries, and cost and management accountants. And second last line covering whole of the PMLA offenses, which is nicely explained by Vijay Dalmia ji. Punishments also covered, now records, reportings, and any conviction we can take in Q&As. About the definition side, all have been covered. One thing I want to also highlight, like Vijay mentioned, Sumit mentioned, that you can't take excuses like section 2U define proceeds of crime. And recently, US Avasti, MD IFCO, mentioned in that his statement that he is not aware of the knowledge of the properties gained by his son. And then there is a judgment came out from appellate tribunal forfeited property, that you are guilty, you can't deny it, that you are not aware of the properties of your family members or your son. Obviously, Vijay ji mentioned about use of property, that property kind of property is very vast term, like in Pulwama attack, that vehicle was used, right? But nobody knows who financed it. It was never published, but it's a contradictory views. But this is a fact. So let's jump upon the corporate side or from the professional firm side, that what we should take care. What we should take care means what a practicing professional should take care. So very simple, whenever you deal with any person, you first conduct the due diligence that is mentioned under section 11A. That is third line of this slide, which talks about that professional being in a regulated entity should verify. Again, I am repeating the term verify. They are not saying that you need to collect, you need to identify that client. You need to verify. Means if some client is coming on your desk, your office, walk-in customers, or maybe a customer or client is in US, that you need to verify their identities. Verify the beneficial owners. So how you will verify? So currently there are only 4 methods are available. Aadhaar authentication under section 11A, offline Aadhaar authentication, use of password, and officially valid documents, right? Aadhaar authentication is not allowed for the reporting entities other than the banks. It will be allowed if your respective institute will give you the approval. In May 2019, that notification came out that Aadhaar authentication can be available for the regulated entities. Regulated entities means professionals. So either I will say RE or I will say professional is equivalent term. So being an RE, professionals should apply to regulators. Regulators means the institute, ICI, ICSI, ICMI. Then they need to satisfy them that they have upgraded their standards in terms of IT security. So then they will recommend, and then second recommendation will go to UIDI. UIDI is an Aadhaar authority. Then they will look upon your IT processes, and then you can authenticate the Aadhaar. But still, final approval will be given by the Ministry of Finance. So that is a one-way authentication, but is currently not available. Institutes will obviously will talk on this matter with the government of India, that how it will be available. Either it will be in a combined platform or how it will happen. So there are a lot of challenges. Offline Aadhaar, obviously integration is required with UIDI website. So that is also not possible. Use of passport you can collect, but how you will verify? Maybe at the time of incorporation, you can verify the passport number in the incorporation forms. But other than that incorporation activity, might be you will take on some other activity of that particular client, but how you will verify those passwords? Officially valid documents means Aadhaar, driving license, ration card, that kind of 6 documents have been mentioned. But once you collect, then how you will verify in digital world? Because challenge is that professional do hardly any meetings with the clients face to face. Assignments are taken from the other professional. Like if I am a company secretary, I will take assignment from Vijay, because Vijay is an advocate, right? He can refer me to the work. So either Vijay will be liable for that carrying out the due diligence of that particular client, or I will be the liable. So a lot of clarity should comes uh, from institute sides, and all the institutes should work together so that professional can work together. So a lot of ambiguity is still there, although they have clearly explained and saying that regulator will come up with their FAQs, they will make their task force that how this can be implemented. Assignments of several tech companies we take, like if we'll say that I will take on a work of Dalmia group. So obviously I need to then carry out the due diligence of each and every entity. If I've taken a subsidiary company's secretarial audit, then I will do that particular company's client due diligence. If I will take an internal audit of another subsidiary, then I need to carry out the client due diligence. So it's in a entity to entity wise. I already explained that we can't store Aadhaar number, Aadhaar information. We can't just use the Aadhaar of the clients as per recent judgment of Supreme Court, which came out in 2018-19, I believe so, in October 2018. So it's very difficult. And then how you will verify KYCs of the foreign clients? Either you will take confidential information report from the regulators of that particular client, from if my client is in Latvia or my client is in Netherlands, so obviously I will write a confidential information request that these people exist in your companies or in your country or not. Or maybe I will take an help of institutes. Maybe chartered accountant institute say that this chartered accountant need a work of Netherlands, so they will connect with the particular authority through institute. So I don't know the framework, but obviously these are the challenges in front of the professionals. 11A, I already covered that respective institute approval, UIDI, Ministry of Corporate Approval is required. So I don't know what institutes will do. Either they will now again assess the progress of all the firms which are peer reviewed. They need to follow AML standards. They need to follow ISO security standards. So that is also a very gray area which needs to be highlighted to the institutes, and clarity should come as soon as possible, because these amendments already effective from 3rd of May and 9th of May, right? Next is to talk about more about the maintenance of records. That minimum 5 years of records we need to maintain of transaction, attempted transaction, or executed transactions. You need to maintain account file. You need to means account file is a vast term. Vast terms mean where if I am in an NBFC or a bank and I'm giving a loan, 100 loans, so I will assign a particular number, account number to a client, that these 100 people have taken a loan from me. This is loan number 1 belongs to X client, number 2 X to this thing. So these kind of account file you need to maintain, and all the business correspondences you do. So either you will if you are taking any management representation for them from them, or you will sharing any report, or you will exchange any of the information, those informations also to be stored. So it's not very easy to implement all such maintenance of record procedures for the practicing chartered accountants, company secretaries, but and cost and management accountant. But yes, there is an immediate need that they need to improve their standards. And there is a contradictory view because in past I have attended several webinars and seminars of with various advocates and other professionals also. People are talking about more in terms of the prevention and control of money laundering. But FATF, Financial Action Task Force recommendation is that we need to combat. It means combat means we need to have a one-on-one fight with the clients. If they are involved in proceeds of crime, if they are involved in terrorist or financing, we need to use our weapons that we work if we in such a manner and as per the firm policies, as per AML procedures, as per KYC's procedures developed by the practicing firms. So never take such a client and never do work of such a client who is not completing the due diligence. Section 12AA is also very important. You need to examine the source of fund, ownership, financial position. So how you will check it, how you will again verify it. They may give you dummy income tax report. They can give you dummy civil reports, but you actually have the credit information portal link or access, or you have any account aggregator licenses so that you can verify their bank accounts. If they will share the OTP, then account aggregator will share with you all the details, saving and current accounts of client or beneficial owners of that particular client. So a lot of ambiguity is there, but I don't know how institute will come on this front, that because verification is utmost important and prime objective of PMLM. You will file suspicious transactions. Suspicious means reasonable ground of belief that there is a process of crime. Reasonable ground of belief is a very vast term. You can write thousands of papers, thousands of pages. From my perspective, it's not on a financial transaction, it's not on a transaction. Any suspicious transaction will be covered here. You need to report being a practicing professional, either in single or in a series. A single transaction can be reported or a batch can be filed on FinGate portal. And these reportings are very complex. I will share a few more slides. But these reportings are not giving you any criminal or any other liability, because you are not liable for any criminal liability or civil liability. If you are a proprietor of a firm, you are not liable for civil and criminal liability. Your employees will also not be covered under that, but a fine can be imposed between 10 to 1,000 rupees. Sorry, 10 to 1 lakh rupees for each failure. Each failure means these are monthly reportings, these are progress reportings. If you have received 10 transactions of cash, being a consultant or being an advisor, so you need to report all those 10 and 10 transactions. If you will skip 5 transactions, so you will be penalized for 5 transactions separately, and the fine can come up to 5 lakh rupees. Search and seizures we can discuss in FAQs, but it's a very plain, plain methods. Vijay can explain it in well manner. Oh, the challenge is also that FID, Financial Intelligence Unit, is only a single office in Delhi, which is in Samrat Hotel, Chanakyapuri, 6th floor. There's only one office. Then there is an appellate tribunal also in Delhi only. So a lot of ambiguity is there, that where we need to report for whole of the pan of India. Either physical reports will be accepted or not. So that kind of challenges will be faced by practicing professionals. In terms of the maintenance of records, so this is an overall, I mentioned all the regulation which is expected from PML maintenance of record rules, that you need to appoint a designated director, principal officers. So this is a corporate governance expected from practicing firms or LLPs, that they will appoint a designated director. Designated director in case of a proprietary firm, then he will be a proprietor. Proprietor himself can be a principal officer, or he can appoint someone. Like if there is any other associate in the firm, then he can appoint a principal officer. So every time, even it is mentioned that every client KYC will be reported to central KYC registry. That is rule number 10 also, and highlighted in first also, that CKYCR is defined, and CKYCR identifier will be allocated to the clients. So these are the rules. Sorry. So what it means means that once you will carry out the due diligence, you need to report those client IDs to the central KYC repository, and you need to take, being on a practicing firm, you need to take on a registration from CKYCR. A lot of notification will come up soon from side of CKYCR, and then CKYCR will allocate in a central KYC identifier number to a client. And before you carry out a due diligence, like if I have a client, now I have allocated that CK identifier number, and now client is not working with me. Now Sumit want to take that client. So Sumit will first screen that customer's CKYCR number from his OVD, officially valid documents, from the portal of CKYCR. So he will screen, he cannot allot second identifier to that particular client. But I don't know, seriously, this is, for me, is like that This is in a trailer from the government side, but picture abhi puri baki hai, to be very honest, that how it will flow. If you actually implement all these procedures, so it will be a very technical uh, challenges you will face, technical glitches will come, and a lot of work required to be done by the practicing professionals. Maintenance of record transactions. Maintenance of records of transaction, cash and above rupees 10 lakh, NPO dealing suspicious transaction, all is covered under Rule 3. Nature record of information, nature, amount, currency, parties, date. This is minimum information should be available in your systems of each client. This is minimum requirement that even under section 12, director FIU can investigate and ask immediately from you. But keep record of these transactions. You should have all these information handy in your form. Internal mechanism. So I will, in other slides I have covered. Registration with FIU. So designated director, principal officer should be reported. They need to be registered with FIU. Their resolutions or their appointment letter should be filed. Maybe you are working in form of company, maybe you work in LLP or partnership form or in a proprietorship form. That should be filed, and there will be an FIU registration will be allocated to the practicing professionals. Internal mechanism of verification, I already discussed that client due diligence is utmost important. So that internal mechanism means your IT infra should be handy, should be available, should be always be available whenever you want to carry out a client due diligence. Your AML tools should be available. AML tools means which throw the alerts that yes, in media that particular company is highlighted, and that automatically triggers in your phone, your laptop, that yeah, this is my client, but now this client information is media. Maybe enforcement agencies have taken action against your client, but client is not informing you. But such kind of tool you need to implement. And so there is a lot of scope for you also that you can develop your own AML tool. So it's from my side, I will say that is a great opportunity for you because you are working in tech side. So actions taken reports. So action taken reports, you have filed some information, but like ROC or like income tax is bounce back, that you need to provide further information so they can inquire, and then you do further submit those reports, action taken reports. And obviously I already discussed that you can't meet face to face the clients. So obviously now digital KYC processes are available. From your side, there should be one person who will carry out that particular due diligence online. They need to show their identity proof. Like at the time of digital signatures, we use that process, then that will be captured properly, then it will be sent to the UIDI or some other regulators, then they will verify the informations, and finally you can say that yes, I have carried out the due diligence non face to face, and I have done a dealing of 1 crore rupees, 2 crore rupees, or it's an assignment of 5 crore rupees. X number of amount you can mention, but there should be also your assignments, memorandum of understanding should be available at that point of time, and they can sign it so that you can justify that I am not maintaining records or storing records in physical form. Expectations, I think this is an overall brief that you need to write your KYC ML procedures. You should carry out your in-house risk assessment around money laundering, that or terrorist financing. You will say that these are my 4 clients which are in Udhampur. These are my 4 clients which are in Arunachal Pradesh. They are very sensitive because they are, from geographical point of view, they are very close to the borders. So that kind of assessment you need to do. Other type of assessment you need to do, that high level transaction clients, that or high level assignments you have. So you carry out that internal mechanism, that this is my overall assessment, and you can present it to any person or any enforcement agency before they ask any information. Like information they will ask that yes, recently, like this is an example. So Sara case happened. So at the time of Sara case, so many cases, so many information is asked from the banks. so many information asked from the NBFCs, because Sara has taken a lot of loans. So loans are provided, loans advisory is always provided by the practicing professionals. So be doubly sure that whenever they comes, they will, you can say that these are the customers due diligence I have carried out, and these are the documents. These are my own in-house risk assessment I have done. These are my categories of the customers. These are high risk customer. This is a medium risk customer. There is a low risk customer, and then you are keeping the records. And then you, on monthly basis, you are reviewing the suspicious transaction or alerts within the practicing firm. Then there will be a reporting, and there will be training. Even a lot of time happens is that practicing professional know, being a proprietor, being a designated director, being in a company, being a director, but they never pass on PMLA information to the supporting staff members. Like there will be a lot of accountants, there will be legal paralegals. So you need to educate them also. So in past also, I have conducted several email training session in NBFCs, in other financial institutions. So this is unexpected, like post, we are providing training. So similarly, email training should be provided to all the practicing professionals forms. I mentioned that I have also linked here these, current regulator guidelines. If an NBFC working under the regulatory framework of RBI, so they came out with the guidelines. So similarly, SEBI intermediaries, stock exchanges, they need to follow SEBI. Insurance intermediaries, then they will follow IRDA requirements. So similarly, institutes will also come with their own guidelines and FAQs. These are the red flags. Like
Somesh, in the interest of time, if you could touch upon the notifications, because there are some questions also coming up, and even I have a lot of questions. So it'll be good to discuss after the presentation is over. So if you could
right.
So, detail on the notifications, yes.
Right. So these are the only 4 transactions which initially came out: buying and selling of any movable property, already discussed, even a power of attorney holder. If you are a GP holder, in case of buying and selling of a property, will it be covered? According to me, it cannot be covered until unless you have accepted any kind of funds. But if you see the language of, you need to check the language of power of attorney, that whether what kind of responsibilities you are taking being a practicing professional. But these are my views that can be changed. Managing client money, obviously you are transferring the funds, then you are guiding. Even if you are guiding on the transfer of funds, even if there is a mail record that you need to transfer, obviously that kind of management will also be covered, except these people, because MOF have exempted stockbroker, share agent. But if you are guiding in emails, if you are guiding in correspondences, I don't know what kind of assignment you are taking, but you are controlling those accounts, you will be covered. So B and C are the very similars. If you are making any strategy, then also you will be covered. Organization, this is utmost important. Creation, if you are involved in incorporation activity, operations mean day-to-day affairs, you are managing of any client, or management means you are a director, you are holding any other position, maybe you are involved in the business activities, like you are involved in annual operating review, you are the attendee there, you have given your advice on their strategies. So that kind of I will say that everything is covered in this last point. If you are thinking that it is limited to incorporation, I believe so that if you will provide any of the inputs in strategy making, also annual operating reviews, quarterly operating reviews, legal long run strategies of the clients, review meetings you are attending, being a chartered accountant, being a cost accountant, you will be covered. Later on 9th of May, they added few more activities. These activities are not applicable, are not just limited to the practicing professional, but to the other designated professional, like casino, like jewelry, so like a real estate agent. So there are other professionals also. So that's why even buying and selling of entities, if those professionals and practicing professionals are involved, so obviously that PMLA will be covered. Even your fiduciary position, even you are acting as an agent, if you are providing any office space, maybe exemptions have been given, but it seems that everything is applicable. We can take your all the queries in Q&As. I've already covered here that acting as a nominee shareholder, even if you are shareholder, so then you will be covered here. Acting as a trustee, if you have some kind of a trustee arrangement or you are running an NGO, if you have an engagement, please review it. Lot of ambiguity is there, that how you are working with NGOs in terms of CSR activities, in terms of CSR funds utilization. So these are the reportings. Next slide. These are the cash transactions, suspicious transactions. You can check it by, these are monthly reports, but suspicious transactions, second number transaction, reasonable ground of suspicion, unusual, unjustified, no economic or bona fide purpose. That is expected if you, from the reasonable ground of suspicion. Aapko lag raha hai, if you feels that this is not a bona fide, this is not an economic purpose, for economic purpose, then that will be a suspicious transaction. You need to report within 7 days. This is in a way of reporting. I have mentioned crux here that there is an account-based reporting. If you have allocated account numbers to your clients, then it will be account-based reportings for CTR, STR, NTR. But for currency purposes, you need to have in a separate format, CRF format. But the crux is that you can do in a batch upload, you can do in a single entry upload on FinGate portal. But I'm mentioning no physical filings, no nil filings are required. Everything to be done through this FinGate portal, and this FinGate portal is more complicated in terms of any other reportings. Maybe it's an XBRL in MCA, maybe it's an income tax reporting. But from last 7-8 years, I'm facing a lot of issues. But we know how to we filed it, but we are also struggling even after 8 years. This is an overall mechanism which is expected, that you being a practicing professional or firm, or you are running a company, then there should be a transaction review committee that is in a charter, that will be the composition, that designated director, principal officer, one fraud controller from your account stream, or maybe from FinOps, that should be involved. Major task is just keep checking your firm, that is there any unusual transaction based on the red alerts. So email tools provide you the red alerts, because it's very impossible to track each and every client's red alerts. And this is the overall scope and responsibility of transaction or suspicious accounts report committee, whatever name you want to call it. That before 10th of every month, when you are reconciling, when you are processing the payment, when you are taking the payments, every 10th or before the 10th, you need to do that such kind of meeting reviews, and you need to record it. And by 15th, you need to file monthly report. If like cash transaction you have accepted of 10 lakh rupees, so by 15th you need to file it, right? So at least 5 days in your hand. So that's from my side, that I told you that this is in a trailer picture of Ibaki from ICI, ICSI, ICNY.
Thank you, Somesh. Let me admit, for the first time, I also, as a fellow company secretary and a lawyer, believe me, after hearing both of you, the learned experts also, still there are so many plethora of queries that remain in the mind, so much of confusion that is there. My high level view is that PMLA, which was earlier meant for BFSI sector, banks, financial institutions, lending agencies, etc., suddenly by virtue of bringing the lakhs of chartered accountants, company secretaries, and CMAs on par with reporting entities, which are banks and NBFCs, which are big and organized. There's a huge confusion, Somesh and Mr. Dalmia. The fact that how can individual now is expected to register with FIU and give monthly reports, and with no tools, no access, no mechanism, how suddenly it's like a child having been given robes of a robot, and now he has to now walk with those heavy armor suddenly without preparation. This is my initial sort of reaction. What I would love to do is I would love to display the notification there and also seek your views. And initially I'll start with my questions, and then also there are many questions which have come up. So allow me a second. Yes. Now, these are the notifications. The first notification is 3rd of May. I want to just dwell. This is bare law I am now displaying, and I want to just make certain things clear for myself and for the other hundreds of people joining in this webinar today to hear experts like you, Mr. Dalmia and Somesh.
Here, I would like to add one thing. If you are looking at the notification,
Yes, sir.
Notification, it's not only CAS, CS, and ICWS who have been covered.
Right.
These all types of professional and individuals who are into this particular business have been covered. Please try to understand.
Right.
Kindly read the explanation one.
Right.
For the purpose of this notification, relevant person includes. Relevant person includes. The thrust is on the word includes.
It is not an
inclusive definition. It is not an exhaustive definition.
Understand.
So these three are the examples, and rest will also be covered. That includes the advocates and other professionals who may be involved with these kind of activities, like creation, operation, and management of companies. Like there are certain websites on the internet who are into the business of providing directors and who are also into the business of creation of companies, formation of companies, etc.
Right.
They all will be covered. It is not only limited to CAS, CS, and ICWS.
Understand. No, very good point, sir. And I want to just start from here. The notification said the central government hereby notifies that the financial transactions carried out by a relevant person on behalf of his client in the course of his or her profession in relation to the following activities shall be an activity for the purpose of said subsection. So the activities are buying and selling of immovable property, managing of client money, securities assets, managing of bank savings securities, organization of contribution for the creation, operation, or management of companies, and creation, operation, or management of companies, LLPs, etc. Now, this has been saying that in exercise of the powers conferred under Section 2(1) SA 6. I want to just throw your attention here on 2(1) SA. It says, this is the definition. It says, person carrying on designated business or profession means person carrying on such other activities as a central government may notify. So by that notification, central government has notified those activities. Therefore, it falls under the definition of person carrying on designated business or profession. Now, anybody who's doing those activities is a person carrying on designated business or profession. And I just want to highlight here reporting entity. Reporting entity means a banking company, financial institution, intermediary, or a person carrying on designated business or profession. So by virtue of this definition, those activities, whoever does that is a person carrying on designated business or profession, and any person who carries on those activities becomes a reporting entity. So therefore, the entire act, which was casting obligations of due diligence, reportings to reporting entities being banks and financial institutions, also apply to those people who are carrying on these activities. This is how, by virtue of simple notification, by change in the definition, suddenly lakhs of people, including professionals, and Mr. Dalmia has highlighted, including CAS, CS, CMS, but not, there could be other people doing these 5 activities also added. Yes, Somesh, you're saying something?
No, I want to say that REs are obligated for registrations, reportings, right? So government is expecting that I am providing you the support for combating, means you are the soldiers in terms of financial terms, right? Of this, and they can provide you the MMGs, LMGs, other guns, but you should to know how to use that. That is very critical and utmost important in today's digital world. So that's why they are empowering you. They are giving you all the technology support so that you can combat. And I already discussed last point, financial transaction carried out by a relevant person, be it is a practicing professional. I am mentioning in the rules also, is mentioned in the maintenance of record rules, your supporting staff, who are the paralegal guys, who are the accountants, who are your HR staff, that also be covered under the relevant definition.
Sure. Question to any of you, Sumesh and Mr. Dalmia, is that it says the financial transactions carried out by a relevant person on behalf of his client. Now, if a practicing professional is creating a company or operating a company or a company, he may get his in that company. Or are we saying that if you're creating a company but also putting in some share capital, or there is the exchange of
in legal, you have seen client is giving you professional fees, party payments, because you have already incurred such expenses, but that expenses are not paid by the client but paid by some other third party. So that kind of transaction you should highlight, and you should review it in your firm, why that client has given that money from another account.
Any comment?
Sumit, in my view, the fee will not be covered. Fee is not a financial transaction.
Right.
Financial transaction has to be read in conjunction with the points 1, 2, 3, 4, and 5. That is buying and selling of any immovable property. So if the client is giving you the money for buying a property for and on his behalf,
right,
managing of client money. Now, if the client is giving you the money to invest in share market, like those kind of services, management of bank savings and securities account, in that particular case, it can fall into the category of financial transaction. Otherwise, plain simpliciter receiving professional fees will not fall into the category of financial transactions.
No, very well said. And therefore, even creation, operation, or management of companies, only if the practicing professional has a role in the financial transactions of the client company, I think then that will be covered. But plain vanilla incorporations should not be covered.
I don't agree, because they have specifically, this you have to take from the perspective of the Chinese companies who have created, committed havoc in the financial world here in India, who have also indulged in money laundering activities. Here the words are, you read 1, 2, 3, 4. 1, 2, 3, 4 points are different from point number 5. Point number 5 is simply dealing with creation, operation, management of the company. So if you are creating the company for some client, for operation and management is slightly different. But creation here, you have to read, means formation of the company.
But Mr. Dalmia, here it says notifies that the financial transactions carried out by a relevant person in relation to the following activities. So where is the financial transaction here in creation of a company, other than the fees that they receive for creation?
Hold on, let us read it again. Hereby notifies that the financial transaction carried out by a relevant person on behalf of his client in the course of his or her profession in relation to the following activities. Now, when a person is creating a company, the person may be paying the government fees, after taking it from the client, or maybe from his own pocket. The idea is to curtail this particular tendency of formation of frivolous companies, fake companies.
Right. Sure.
So the words are little bit different. These words may be loosely drafted also, but we have to go behind the real intent. And real intent is financial transactions relating to creation of companies.
Understand. So I think the message that is coming out is plain vanilla incorporation and taking your fees may not be sort of bad or regulated. However, if you're routing, if you're taking say lakhs of rupees as on behalf of the client, or maybe paying on behalf of the client maybe in the garb of some statutory means. Normally certain fees is paid by the firm, they reimburse, but sometimes it may be huge stamp duties. It may not be exactly what you receive, what you pay, and why you pay, etc. So if there are certain financial transactions which are being done by the practicing side, or by any person on behalf of the client, that may be under the radar of PMLA. That's what broadly the message is coming out to be.
And Sumit, last thing I am highlighting, financial transactions means two words. And the transaction itself defined in the maintenance of record rules. And transactions mean even if you are carrying out for corporate any gift deed of shares transfer, that transaction also be covered because my fund has not been moved, but it's in a financial transaction. So transaction is widely defined in the transfer this PMLA rules 2005.
Understand. Okay, the next notification was 9th of May, which says, now it doesn't contain the word transaction. It says, the central government hereby notifies the following activities when carried out in the course of business on behalf of or for another person, as the case may be, as an activity under the same subclause. So the clause that I showed you, these additional 5 activities have been included if it is done by anybody on behalf of another person. So acting as formation agent of companies or LLPs, acting as a director or secretary of a company, partner of a firm, etc., providing a registered office, business address, accommodation, correspondence address, etc., acting as a trustee for an NGO, or it could be even probably a director of a Section 8 company, acting as a nominee shareholder for another person. Now, this is very, very important. Again, thousands of professionals being CS, CS, CMS, would be providing registered office services to their clients, because it may be a foreign client with no place of business in India, or it may be a new startup who may not have taken a place of business, and they would need, and these are very legit services provided globally, even companies in Singapore, companies in Mauritius, practicing people, including the big law firms, I would say, on record, would lend their offices in a very legit way as their registered office or a correspondence address, or even certain people would be non-executive directors on their client companies for a professional fee or a sitting fee. Now, what is bad in that, and why? My first question is, what is meant by on behalf of another person? So if I'm acting as a director in a company, I'm acting a director in my professional capacity, but I'm not acting on behalf of another person. I'm acting on my own behalf. That is, so I'm not very clear on what is meant by on behalf of another person. Similarly, if we provide a registered office here, and then the exception says if you have signed a lease deed or a sublease, then that is okay. So it's slightly confusing. If anyone could clarify.
Okay, let me put it. In 3rd May notification, the word profession has been used. In the 9th May notification, the word business has been used during the course of their business. Right? That is one thing. So here they are not targeting the professionals. Secondly, why the word director is coming here with reference to particularly foreign companies. Now, what is happening that people are lending their names as directors, because when a foreign company is being incorporated in India, the compulsion is that you need to have an Indian resident director.
Right.
Right. So what is happening that they don't find an Indian resident director. What is happening? People are lending their name. So they are into the kind of business of providing their name. It is not professional activity.
Sir, with due respect, for example, tomorrow a client comes to you and says, Mr. Dalmia, would you like to be a non-executive director in my company? Because of course I need one resident director, and you say, and you consent to it. There could be some nominal fees, but then you attend the board meetings, you provide your legal expertise, you provide your overall experience and expertise in running the corporate governance of that company, and you review the balance sheets and you do the board meetings the way they should be done, and ensure that as a conscious keeper of the Indian law, because they are a foreign company, there could be foreign directors, but you are the Indian director and the conscious keeper. What is the harm in lending that name?
There is no harm at all, but when there is only lending of name, that they want to cut it.
Sure.
When you are into the business, means if you are a director in a company or two companies, that is okay, you report. But when you are into so many companies, that is the maximum possible companies where you can be a director. It has become a kind of business. That is what they are trying to prevent.
Sure. Understand. Somesh, any views?
In short, I can say that being a regulated entity, these practicing professional should take care of all the transaction, because the PMLA work, PMLA Act or rules only revolves around the word transaction. Maybe it's a financial, non-financial, but obligation is to review your transactions. That's it from my side.
Understand. All right. So now couple of more questions. So Somesh, for example, these client due diligence, designated director. So as every reporting entity has to designate a director and report it to the authority that this is the principal officer or designated director. Now, do you think is it practical for all practicing firms to designate a director? And when we also talk of transactions of suspicious transactions, in the banking context, it is easy to understand that if there's a cash transaction above 10 lakh rupees in a month, you report it to the FIU by way of monthly returns. But here, on the practicing side, who are just directors in companies or maybe creating a company or managing a company, they may not have access to the financial books of accounts or records or bank account. So how can all these transactions be reported where they may not have even access to it?
I think this question is really meant for Vijay ji, because I am giving highlight on that designated director. One of the section talk about that all obligation for the compliances is casted on the designated director, so that in the litigation he can't deny that I am not aware of PMLA. I have not taken a trainings. I have not given a trainings to my these supporting staff. And principal officer's obligation is only limited to maintenance of records and reportings. So you can hire within your firm for the reportings and creating the records, but obligation is on the designated director, because he is the ultimate, he is having the ultimate powers for controlling the affairs of that particular firm. And in litigations, again, we are mentioning and quoting the same thing. You can't deny that I am not aware that how this property bought by my client or my relatives. So that kind of questions will come on designated director.
Surely. Okay, so there are a few questions which have come up. I'll ask those questions. Sumesh and Mr. Dalmia, any one of you can sort of volunteer to answer. So I'll read out the question. Have corporate entities that are not financial institutions brought under the ambit of PMLA with the new amendments with the definition of group?
With the definition of?
Group. Or let's ignore the definition of group, but generally have corporate entities brought under the ambit of PMLA along with financial institutions?
Corporate entities per se have not been brought into the purview of PMLA. It is otherwise. It is the other way that has been done. Those who are dealing with these entities, they have been brought under PMLA. The ideas of these two notifications are slightly different.
Right. I think whoever is conducting those activities, whether corporate or non-corporate, whether corporate or individual, doing the activities which have been notified are under the radar of PMLA, basically.
Like, let me give you an example of co-working spaces.
Right.
What they are doing, they are providing their premises for the purpose of GST numbers and other things for opening of the registered office, etc. Now, those are the entities who have been brought under these notifications.
Right. Surely. Okay, what are the steps to be taken by chartered accountant or a company secretary to ensure that the client should not be under the radar of ED? That's a very wide question. I think
I can give an answer.
Yes.
There can't be any steps that can be taken, preventive steps that can be taken to prevent the clients or the corporates to be not under the radar of ED. If you commit a scheduled offense, you are under the radar of ED. If you are a reporting entity, you have to report. There is no exception to it.
Understand. You know, one case I would like to cite here, not cite, but I would like to share the facts, which I happen to experience it myself. We were reviewing an agreement of a client wherein there was a simple scope of work, and the money, the exchange money, I mean, the consideration was 3 crore rupees, single one-shot payment in exchange of those two-liner scope of work. And you know, the recipient of that money was a newly formed one-person company, OPC. So, you know, while the agreement came for a legal review, more than the legal, you know, my question was on the transaction that, you know, the scope of work is just two-line. The recipient seems to be just a new company, which is an OPC. And you're saying that 3 crore is the value of the services that is going. So I think as professionals, lawyers or CA or CS, one is the legal aspect of an agreement, but the other is the underlying aspect of an agreement that we need to be very vigilant about. If in the garb of a service agreement, huge money or crores of money is being sort of tried, you know, exchanging hands, you are well within your right under PMLA to question your client, to first do a due diligence or an enhanced due diligence of your client. And if you're not comfortable, you know, sever your relationship with those clients and maybe report wherever the reportings are to be done. But Mr. Dalmia, if in the course of our professional duties we come across such suspicious sort of transaction, which is not a financial transaction, but the example that I just gave, by virtue of an agreement which is about to be signed, and we are reviewing that agreement. Now, where should we report? What should we do?
There should not be. There is no need of any reporting until that person becomes your client.
Right.
That is one thing. If somebody is coming to you disclosing certain things, it is not under your obligation to go to the appropriate authorities and report each and every person who has come to you. That
right.
person may be genuine, may be ingenuine, may be wanting to do the actual business, maybe just window shopping, in the sense that you are not supposed to report. But if you are engaged with a particular client, only in that case your obligations will start.
Right. Understand. No, but if we are engaged with a client and suddenly in midway we realize that he is not, he's probably about to commit or is committing a scheduled offense in the nature of money laundering, then what should we do?
About to commit, no reporting, but if he is committing, reporting.
Okay, understand.
Just to give you another example, Sumit, many times happens, one of the customer comes in NBFC or a bank, say that I need 50 crore rupees loan, but he is sweating and given KYCs, then he vanished off after giving these details. So obviously bank manager or NBFC manager or kind of professional should look upon the, should put the lens that why that particular person is looking for 50 crore rupees of loan. So you can, as mentioned by Vijay, that you can mention and you can report it.
Right. Okay. What are the reporting obligations when you are only helping the client with registered office and directorship services, where there would be no visibility of financial transactions?
If it is your business, then reportings will come. If you are doing your professional activity in that course, it is you are not supposed to report, because we have to distinguish between the two notifications, 3rd May notification, 9th May notification. I have pointed out two words, profession and business.
Right.
So we have to look from that perspective. If you are a chartered accountant, company secretary, you are providing your professional services, no reporting is to be done. But if you are into the business, if you are running a website for formation of companies, in that particular case, you are into the business of formation of companies. You may be employing others. In that particular case, the situation is different. So slightly, we have to also holistically synchronize both the notifications. It's not that the government is after the life of chartered accountants or company secretaries or professionals. It is basically to bring a sense of responsibility in them.
Right. So do the CA and CS and even the directors need to register themselves anywhere? after this notifications?
My answer is no, it is not required.
Somesh, what is your opinion?
No, aligned with my partner.
Right,
No.
right. Although I think more clarity needs to emerge in all these aspects by virtue of probably amendment in the rules or the which should prescribe certain procedures, because if suddenly people fall in the definition of reporting entity, which was earlier meant for banks and financial institution, I think a lot more clarity is required for individuals and small businesses. Okay. Could you please throw some light on Rule 9, especially description of account-based relationship?
Vijay, you want to take?
You please take it.
Account-based relationship means you need to allocate customer identification number. And then you will say that you will do several transactions with that particular client. Maybe first you will be involved for the incorporation, then they will be involved as per your memorandum of understanding for understanding the business strategy, and you will provide any sample report that you should work upon these matters. You can launch those products. You can help in the regulatory licenses. You can help as a designated board member in their companies. So series of transaction is carried out under an account. So that's why I have again I am repeating it. There are two ways of reporting in FIU. One is account based, one is transaction based. So account based means you have allocated an account to a client, and within that account you have provided 5 information. One, cash transaction more than 10 lakh rupees. One, suspicious transaction, but because you was a director but they were not providing you the records. Third transaction is currency related, counterfeit currency, that you have seen that there will be a illegitimate currency. Then you have reported these 3 things when you are dealing with an account. Account means account of a client.
Right. Sumesh, you had also mentioned the central KYC registry, CKYCR, etc.
Right.
Again, the access of these registries have been open to financial institutions and banks. Now, if the CACS onboard any new client, of course they should do a client due diligence, as you were saying. They should take the Aadhaar or the PAN or other officially valid documents. They should take a memorandum and articles of their client, etc. So that documents can be taken. But are they required to file it with the CKYCR? Because again, there is no mechanism, no guidance on how will they get access to those registries, etc., etc.
So recently, Digital Lending Association (DLI) given to representation to RBI also that whether we need to file a record or whether we need to file an information. So from earlier in CKYCR, we used to file scanned signatures also of the customer. We used to file OVD also, officially valid documents, and we need to file deemed OVD also. Deemed OVD means if Aadhaar is not having your current address, then you need to take a rent agreement from the customer, right? From the client. So those deemed OVDs also we need to file with the CKYCR. But as per the latest news coming from RBI and from the CKYCR, as per my conversation with them, and as per my knowledge and as per my reportings which I am managing, we are not filing so many documents. The logic behind is that CKYCR is having several filters and API integration with MC also and with other regulators also.
All right. So I think clarity still needs to emerge with respect to these individuals. Do the new regulations mean that even statutory auditors have to report suspected PMLA transactions to the appropriate authority? Mr. Dalmia?
Obviously, they are the practicing one. So they need to file suspicious transaction. They need to file other transaction. If they can report to the RBI about the bank or about the NBFC, so they can additionally file the same fraud reports to the FIU.
Right. Understand. Vijay, question for you. Why, somebody specific question to you addressed by the audience. Why environmental law violations have been included as a scheduled offense, and what are the implications for any company?
Sir, in case of legislation, there is no why. First of all, it is the desire of the legislature. It is the collective desire of the legislature, and because environment is a big aspect relating to the society. So that is the probable reason the environmental laws have been included in the schedule. Otherwise, I can't give any better answer to it.
Understand. So we are almost at the verge of wrapping up the session. I'll request my team to showcase a small 1-minute presentation on Complinity, and then we move to wrapping up the session. So team.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management, request a demo at complinity.com.
All right, thank you. So we are almost at the end of the session. I'll quickly launch a closing poll as well. Are you using any compliance software? And if would you like to have a demo of Complinity compliance software? So while it's a simple yes and no, while people are answering that, we'll move to the towards the end of the session. So any last words from you, Mr. Dalmia, on PMLA and the recent notifications?
As far as PMLA is concerned, it is a very important law, and one must definitely take care not to get involved with the PMLA activities, because it not only results in criminal prosecution, but it also economically ruins the person who is involved in the PMLA activities, because there is a confiscation, attachment of the properties, taking possession of the properties, confiscation of the properties. And at least I can tell you, I have seen the clients who are coming to me with thousands of crores of rupees worth PMLA allegations and saying that they don't have the fees to pay me. So that is the kind of disaster they may face.
Yeah. You should start charging your fees, Mr. Dalmia, as a percentage of the offense, offense, the involved in the offense.
That is not allowed in India. That is not legally allowed.
Understand. Okay, Somesh, any last words from you on PMLA and the recent notifications?
I already mentioned, Sumit, you need to combat. Combat is, you need to play like in a Virat Kohli on the front foot, not on the back foot. So obviously you need to challenge before you are taking any assignment from the client. Yes, these are the requirements from the government of India. We need to follow, and we will play and we will work on the front foot only. We are not the ones, we are not the practicing professional. We are just hungry for the work. We are following the compliances, obligations of the PMLA, and we are working with foreign clients. Obviously, we need to take good certificates, character certificates from foreign respective countries also of that particular client.
Right. From my side, I think I would like to sum up saying that we should not be totally scared. We just need to be a little more vigilant. By we, I mean people who are dealing with their clients and incorporating companies, acting as directors, or giving their offices as registered offices. Per se, these activities are not banned or bad. However, what is required is the KYC to start with. So the Act very clearly now says that as a reporting entity or as an entity covered under PMLA, before we start engaging with any client, we need to not only obtain, if it's a corporate client, their MOA, AOA, board resolutions of the companies. Also look at the beneficial owners who are the ultimate shareholders of that company and obtain their passports, if it's a foreigner, etc. Or in case of Indian, PAN card, Aadhaar card, etc. So first of all, the KYC is the bare minimum that we need to start with. I don't know whether we'll have mechanisms to validate or verify, as Somesh was saying. But even if the mechanisms don't exist, obtaining a self-certified KYC is the step in the first direction. If you can do a face-to-face meeting with the client, go ahead and do that. Talk not just about your assignment, but also about the business of the company, the headcount, the turnover, the locations, the background, the history. Look at the website and maintain these records for your own KYC purpose. That is the first thing. So, and also a basic due diligence on the compliances or non-compliances, any show cause notices as they have been issued, any litigations going on. So basic due diligence before we onboard any client so that we work with the compliant clients. I think this is the first message by virtue of these notifications. Second, even when we are lending the registered office, etc., there has to be a proper agreement, either a lease deed or a leave and license agreement, rental paid through banking channels, TDS deducted. So then lending the office is per se not bad if all the compliances and all the paperwork and documentation is in place. Similarly, if you're a director, if you are actually sitting in the board meetings, taking a sitting fees or a professional fees, contributing, and if you come across any suspicious transaction by virtue of your being on the board, and if you're either escalating, reporting to the board, to the audit committee, or to the authorities under PMLA, or maybe stepping back and resigning in case you feel smell any rat over there. I think these are some basic fundamental things that professionals should do. Even on the employment side, if you're the CFO, company secretary, chartered accountant, PMLA or non-PMLA, we know, I mean, we don't need to look at all the 50 pages of schedules to see what is an offense, what is not. We know what are offenses. Fraud under Companies Act, we don't need to really read that schedule to see what is fraud and what is not fraud. So I think hand on our heart, if there is a suspicious fishy transaction, if we as a conscience keeper or a flag bearer or a torch bearer, put our foot down and refuse to sort of concede in as a practicing side or on the employment side, I think we will be doing what is expected of us to do. And then the EDs and the directors and the other administrative and judicial authorities, whenever they knock your door or our doors, if you have sufficient evidence to tell that, okay, you did your due diligence, you exercised all the basic care. Despite that, if somebody without your consent or connivance is undertaking a money laundering transaction, you may not be held responsible. So I think on that note, we'll end this webinar. Thank you everyone for joining in. And thank you, Mr. Dalmia, and thank you so much for a wonderful presentation and an engaging talk. Thank you very much.
Thank you very much. Thank you.
Thank you. Bye.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.